When we start your trial, during opening arguments, can I tell the jury what the law is in your particular case? You want to know the answer? Come join me for a moment as I share with you the answer to this question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is no, I cannot tell the jury what the law is in your particular case. That's the judge's function. The judge will tell the jury exactly what the law is. Now, I can sometimes hint at it. I can sometimes give examples of it without telling them that this is the law in your case. But during jury selection, when we have a chance to talk to the jury about who they are, what their background is, what their experience is, you should know that the attorneys are not permitted to go ahead and tell the jury what the law is. Now, why is that? That's because that is solely the function of the judge. The judge is the one who tells the jury what the law is. The judge controls what evidence comes in, what witnesses will testify, what we are allowed to say and what we are not allowed to say. At the end of your trial, the judge is the one who tells the jury exactly what the law is in your particular case. And the jury's function is to go ahead and decide what the facts are and to apply the facts to the law as he gives it to them. So to go back to the title of this video, is it ever appropriate for an attorney during opening arguments to tell the jury what the law is? For example, ladies and gentlemen, you don't have to be here for weeks and weeks in order to truly understand whether or not this doctor was careless and violated the basic standards of medical care. Because if you did that, you'd be sitting here trying to make absolutely certain with 100% certainty that what we are claiming is true. And you should know the law doesn't allow that to happen. The law doesn't require that. So what does the law require? The law only requires that we show that we are slightly more likely right than wrong than what we are claiming is true. That's it. Just a little bit more than 50%. If we can do that, then we are entitled to a verdict in our favor. Now, if I start to say that, I guarantee you the defense lawyer would jump up out of his seat as if somebody pressed an ejection button and then argue to the judge, "Judge, he's telling the jury what the law is." And although what I'm explaining to the jury is factually correct and legally correct, I'm not permitted to explain that to the jury. That's the judge's role. So, if an attorney does that during opening arguments, you can bet that he's going to get an objection. The judge is going to tell him, "Don't do that, counselor, move on," and going to tell the jury, "Listen, I will tell you what the law is at the end of this case, nobody else." So why do I share this quick video with you? I share it with you just to give you a sense of exactly what happens in these medical malpractice cases, especially during opening arguments here in New York. And I do recognize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter happened in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.